problem. Starting now.
Okay. Good morning. Welcome to the second pre-inquiry meeting in relation to the Berwick Bank Wind Farm Onshore Works Compulsory Purchase Order 2023. My name is Paul Coquette and I'm a DPA reporter appointed to report to Scottish Ministers into this order. As I've indicated, this is the second pre-inquiry meeting into this order. The first was held on 30th of June, and a note of that first meeting is available on the DPA website, as indicated before, along with all the documents that are relevant to this particular order. And that can be found under the search in the case reference CPO-210-2. I understand that further documents in relation to EIA materials are in the process of being uploaded onto the DPA case management system, but otherwise all documents are up to date and on the CMS for parties to access in the course of this examination. I'll repeat what I said previously about meetings of this nature, in that the meetings are recorded, as you all know, for the purposes of being uploaded onto the DPA website and are available on live streaming as we speak, and the participation in this meeting is taken as consent for DPA and GDPR purposes. It's not my intention to repeat the introductory comments I made from the June pre-inquiry meeting. I think apart from the acquiring authority now being represented by council, I think the parties are probably the same ones who attended that meeting, and so my comments there apply equally to the meeting this morning. Since that meeting, two things of significance have happened, one of which is we had a site visit on the 28th of August, attended by the acquiring authority and was attended in full by one objector, Mr Jimison, who's on the call this morning. Again, here, the second issue is that one objection by David and Caroline Crichton, represented by Bell Rural, have withdrawn their objection. All other objections are, as far as I understand, thus far, are maintained. So, won't go into introductory words. I'll maybe just ask, starting with agents for the acquiring authority, just to introduce themselves so I'm clear as to who's on the meeting. I know people are in rooms and various things, so I'm seeing some names on screen, but if I can invite the acquiring authority, Mr Mackay, introduce himself and those who are present on behalf of the acquiring authority.
Yes, sir. My name is Mark. I'm King's Counsel at the Scottish Bar, and I'm instructed along with my Leonard Junior, Mr Nick McAndrew, advocate, who is sitting in the Athol meeting room with our instructing solicitor, Mr Hamilton. And it might be useful if Mr Hamilton just confirms who's present. I think the list has already been provided, sir, to confirm, but Mr Hamilton will be able to confirm exactly who's in attendance at the solicitor's office.
Morning, sir. We've got to my right is Mr McAndrew, and then going to my left we have Miss Emily Wallace, solicitor for SSE Legal. We have Ashley McCann, associate at Gillespie McAndrew. Sarah Edwards, consents manager for SSE. Simon Hinson, consents manager for SSE. John Hillis of Blackwell and Powis, land agents to the acquiring authority. Conor Manning, engineering manager for SSE. And Russell Fox, I beg your pardon, Russell Fox, who's a land manager for SSE.
Okay, thank you. Just going around my screen, I see Kevin Jimison, non-statutory objector, is present, so thank you. Katie Abrahams on behalf of ENGL, I think in the absence of Alta Burnett KC this morning. Katie, you have anybody with you or just yourself?
It's just myself today.
Just yourself, excellent. And we have Maurice O'Carroll, who's instructed, I think, by Turk and Cornwall on behalf of William Dunlop.
Good morning, sir. Maurice O'Carroll here. Can you hear me okay?
Yes, all perfect, thank you.
Good. I'm here accompanied by Mr. Christopher Hoyle from Turk and Cornwall, my instructing solicitors, and also Finlay Clark is on the line, with Bidwell's property consultants.
Let's take those names again. Who's on the line with you from Turk and Cornwall?
Christopher Hoyle, Hoyle,
Christopher Hoyle.
And Finlay, Finlay, Clark.
Finlay Clark, thank you.
That's us.
Okay, thank you. And I see Scott McCallum from Shepherd and Wedderburn, I think representing NNG.
That's right. Good morning, sir. Sir, I'm joined this morning to my immediate right by Mr. David Sweeney, who is the development manager at NNG. To Mr. Sweeney's right is Mr. Jeremy Bailey, the head of legal for NNG. To my left is Mr. George Bruce, who is a solicitor at Sheffield Wedderburn Solicitors.
Okay, thank you. And I see Lewis Crofts from Lindsay's, I think, who is acting on behalf of George and Brian Ainsley.
Yeah, just me. So for George Ainsley and Brian Ainsley and the kind of trustees for the G&A and B&B Ainsley farming partnership as well.
Okay, that's fine. I'm seeing Fraser Mitchell of Sheffield and Wedderburn for, I think, presumably for Nuclear Liabilities Fund.
Morning, sir. That's correct, for the Nuclear Liabilities Fund. And I'm also just flying solo this morning.
Okay, that's fine, thank you. Now I'm looking for CMS Davison and Robertson on behalf of Tarmac Cement and Lime.
Good morning, sir. My name's Alana Barker and
Yes.
I'm associate at CMS, and I'll be acting for Tarmac Cement and Lime Limited today. Also accompanying me is Mark McMurray, partner at CMS.
Thank you, yes. That's all fine. Dan Johnson, on behalf of Louise, David Dorothy and William Muffet from DDM Architecture.
Good morning, sir. Yes, Giles Johnston here on behalf of the firm of William Moffat and the partners thereof, on my own.
All right, okay, thank you. I'm just looking down the list. Who have I not covered? Michael Bell.
Good morning, sir.
Bell.
Yep.
Yep.
I'm present, acting on behalf of A. Taylor and A. Taylor and Son.
Okay, excellent, thank you. Peter Ferguson, Harper McLeod, William and Donna Christensen. Is Peter present this morning? Okay. And is there anybody else I've not covered? As I say, it's not always very straightforward to make sure you cover everybody when there's meeting rooms concerned, but if I missed anybody out, just let me know. Okay, well, thank you. Thank you all for attending this morning. Quite a reasonable cast of people, which is always useful and helpful to work through the issues we need to address today. I should just perhaps summarise before going into the kind of the meat of the issues on the agenda. Since my last communication to you through...
Excuse me, sorry.
Beg your pardon?
Sorry, we've been missed off your list, sir.
Okay.
Magdalena McLean on behalf of SP Transmission and SP Distribution.
Okay, bear with me a second. So SP Transmission and Distribution, would you say?
Yes.
Okay, thank you.
And I'm joined today by Mr. Mark Peebles of SP Energy Networks in House Legal and Alison Hetherington, who's a solicitor in Sheffield and Wedderburn.
Alison Hetherington. Okay, thank you. Yeah, I was just going to update or just put on record since my last communication with you through our DPA case officer of 8th of November. There have been a number of communications that have come in during the past few days. One of which is Mr. Jimson's alternative suggestion, which was in response to my email of 8th November, had come in shortly after I'd issued that. We have Dunlop have indicated that the earlier alternative suggestion that was being discussed at the pre-inquiry meeting on 30th of June is not being insisted upon. We'll talk about other alternatives a bit later on. We have the acquiring authority's note from yesterday on alternative sites, which I trust all parties have seen. We've had the email from ENGL, CMS on behalf ENGL, which I think has been circulated more widely to all parties this morning. And lastly, we have an email from Mr. Jimson that came in late last night that hopefully everyone has had a chance to see. So that's just to update on the various communications that have been received in the past few days. I should emphasise and stress to parties the importance of making sure there's quite a number of parties involved, and to stress the importance that all communications to relevant parties should be copied to those who are on the kind of standard circulation of list for those who have made objections and made representations in this regard. And I say that particularly because the ENGL email had only a limited circulation, and so it was only seen by Mr. Jimson and Mr. Carroll shortly before 8 o'clock this morning, which is obviously only around 2 hours of notice ahead of this meeting for an email. I think it was issued on Tuesday, and so it's obviously not particularly satisfactory for people to see these things quite late. So I just remind parties of the importance of making sure that everybody who has expressed an interest and is involved in the process is copied in on all relevant communications in relation to matters that are before me for reporting. We have circulated and amended at various points an agenda for the meeting, but I think you've all seen an agenda for that. I may not stick exactly to the order of the agenda this morning, but before we get started in detail, if anybody has any points, any questions of clarification or further items they want to refer to in our discussion this morning that they're aware of at the start of the meeting, please could you indicate that at this stage so we can look to modify the agenda as need to be. So if anybody has anything, please feel free to say. See, it doesn't look as though anybody's got any changes or suggestions to the agenda. As I say, I may dot about it a little bit just because of the way that the discussions have been going. And one of those sets of discussions relate to the discussions in recent days about the possibility of exploring further an alternative site. And going into this meeting, in my mind as a generality, I'm slightly separating out the issues in relation to an examination of possible alternative sites with the other range of objections that have been made to do with prematurity and other aspects of things. And in very broad terms, I'll be looking in this meeting in deciding the next and appropriate steps to be undertaken to be looking at the alternative site issues and all the other collective issues to do with matters not relating to the alternative site. So that's how I'm intending to structure the discussion this morning. And I do realise actually in relation to the Dunlop's issue, the Dunlop objection, there is a degree of overlap between the two because some of the alternative site objections also play into William Dunlop's objection in relation to the site that's been identified already. So I am conscious that the divide between the two is not absolute, but in general terms, procedurally, my starting point from this morning is to treat these separately as far as the discussion on next procedures are concerned. So firstly for this morning, I'm going to start at item 2, which is the position regarding the planning application for East Lothian Council, which is now set for consideration on the 5th of December. And I wonder if I could ask the acquiring authority just to give us an update as to what they're thinking, an understanding in relation to that consent is at this stage. To a fairly significant extent, next steps are going to be dependent on the outcome of the planning application if it's considered the 5th of December. But if the acquiring authority have any information about the likelihood of that being considered on that date, it would be useful to know that at this stage so we can get indication as to how we can take matters on for going forward. So Mr. Mackay, do you have anything you can update me and objectors to in relation to the planning authority's consideration?
Yes, sir. The planning authority's understanding, based on discussions with the planning officers at the planning authority, is that the application will be considered on the 5th of December.
Okay, that's all fine. And as I say, my assumption just now, in terms of looking at next procedures, is that the planning application will be approved on the basis that if it weren't to be approved, that would change the dynamics very significantly for the applicants, the acquiring authorities application if they haven't got planning consent, and will play into a whole series of other issues that are relevant for me when it comes to examination later on. So I'm not closing my mind to the possibility that the consent may not be secured. But I think for current planning purposes, we need to work on that basis. If you could, though, please advise me of the outcome of that planning consent, obviously as soon as reasonably possible after the 5th of December. In addition, I'm not completely sure whether this will arise, but if the consideration by the planning authority gives rise to any implications, it may not, but if there are any implications in relation, for example, to the extent of land take, that because of the nature of the consent that's given, so if there's any changes to the acquiring authority's proposal in relation to what is the outcome of the council's consideration on 5th of December, could I ask the acquiring authority to advise me and obviously other parties as soon as they can? You'll know quite quickly what those implications are, but if you could do that, we'll come to other timetables and deadlines later on, but if you could do that by 19th December, then we'll have a clear indication then as to what the full implications of the decision by the authority and, as I say, any consequential implications for the proposals of the acquiring authority after that. So that'd be very, very helpful if the acquiring authority were to do that. Going on to the list of necessary consents, which has been provided on the 7th of November by the acquiring authority on my request, very grateful for that. That's extremely helpful to allow me to get an overall view of the wider context of the other consent processes that require to be undertaken. This may be relevant to some of the arguments that were put to me in connection with prematurity. So I'm grateful to the acquiring authority for providing that. I had a couple of questions. I'm going to offer other parties an opportunity to comment on anything arising from that list in a minute. But I had two questions. One of which is covered to a certain extent in the covering note when this was submitted, is a note that the consents include certain dependencies relating to consent south of the border for Northumberland Council and the like. And it'd be useful if Mr. Mackay could just give a broad indication as to the extent to which the current compulsory purchase order is dependent on the granting of the necessary marine consents by authorities in Northumberland and elsewhere, i.e. out with Scottish ministers. The reason I'm asking that question is that obviously I'll be reporting on the compulsory purchase order to Scottish ministers who are the same deciding authority as they are in relation to the energy and marine consents as they apply within Scottish jurisdiction. And so questions then may end up being slightly less relevant about conditionality because it's the same deciding authority, but that's not the case in relation to authorities for Northumberland. So I just wondered whether there's anything you want to say, Mr. Mackay, at this stage about the degree of conditionality for this acquisition in consequence of the need to secure consent from Northumberland and other authorities out with Scotland.
Yeah, so that's quite a technical question that's been raised, and there wasn't any real indication given in the agenda, so I don't think it's appropriate for me to say anything other than that we can confirm the position in writing following today's call. It is one of the principal consents, as you know, sir, that is required. But as to the specific question that you've raised, I think it'd be better if we confirm that.
Okay.
Mr. Hamilton may be able to provide the clarification looking for, but I think, speaking personally, I prefer it done in writing after.
Yeah. I think he alluded to that, Mr. Hamilton, in his last letter, did allude to that. And if he is able to confirm that, fine. If he's not, we can proceed accordingly. And this might end up relating to my second question. Mr. Hamilton, first of all, in case you do have anything you can add to that.
Thank you, sir. I think, as Mr. Mackay has said, it would be best to answer that in writing.
That's absolutely right. I'll ask my second question because this actually might actually relate to similar sorts of considerations. I've noticed that there were other conditional consent aspects of the proposal relating to consents from Historic Environment Scotland, from SEPA, and in respect other than planning from East Lothian Council. Now, the note indicates these are being applied for later. My sense in reading that note, I understand that those are different processes. They're matters decided by different parties. They're not for ministers to decide in this process, but they are nevertheless, insofar as they're essential and conditional for the proposal to proceed. Those consents will be needed. As I say, the note recognises that it'll be required later. It does strike me that when we get to the kind of evidential or presentational arguments of the acquiring authority's case, I will want to be updated as to the prospects of getting the various consents that are set out in that section of that table. In the same way that as is normal for compulsory purchase, if the compulsory purchase had been sought without a planning consent in place, now that may not happen in this case because of what the council are about to consider, the guidance on CPO would require me to be reasonably satisfied that there's a prospect of obtaining the planning consent. So by analogy, I wanted to indicate that I would expect to be addressed at some point on the prospects of obtaining the necessary consents from Historic Environment Scotland, from SEPA and from East Lothian Council on non-planning matters, recognising those are not decisions for me or for ministers and that they will be coming later in the process. But I wanted just to flag that up, give notice to acquiring authority that that's an issue in my mind.
Yeah, I'm glad that no doubt will be noted by the team. Thank you.
Thank you. Now, I'd like to open up, unless the acquiring authority wishes to say anything more about their note. It was a very full and clear note and made sense to me, which is very helpful. But unless they have anything further they want to say, do any other parties want to chip in at this point on anything in relation to that note of necessary consent? If anybody does, they may just have to speak, because I can see some people on screen, but I don't necessarily see everybody on screen on video. So just chip in if there is. Doesn't look as if anybody wanted to comment on that. It's fine. Okay. Next then, and I mentioned at the beginning of my introduction to the agenda that my sense is that we should separate out issues relating to the proposed alternatives from the various other sets of issues that are likely to arise. These are the non-alternative site issues. And the question I wanted to address, first of all, with the acquiring authority, but also with those other objectors who have raised objections that don't relate to alternative sites, as to what the next procedural stage should be in relation to those matters. I think the acquiring authority have sought a little bit more clarification in relation to what those outstanding objections actually are, and asked for, made the suggestion that further statements of case be provided to me in relation to those objections, so that the non-alternative site issues can be clarified and identified at this stage. But I wonder if I could start with Mr. Mackay as to what the acquiring authority's position is and whether he has anything by way of update in relation to the objections of a non-alternative site basis.
So in terms of the objections that don't relate to alternatives?
Correct. Yes, yeah. I'm drawing the distinction here from Mr. Hamilton's email on the 7th of November that drew that distinction to a degree. It doesn't fully work for the unlawful objection, but it generally works, I think, that there's a suggestion that we can look to address things separately. And I think in Mr. Hamilton's email, he's suggesting, which I'd like to explore this morning, suggesting that for the non-alternative site objections, it might be possible to address these matters by written submission rather than oral procedure. But Mr. Mackay.
Yes, that essentially remains the acquiring authority's position, that all of those other issues could be dealt with by way of written submission. There's a passion to efficiency, time management, lots of other factors which would suggest that's an appropriate mechanism for those objections. It is accepted that so far as the Dunlop and potentially also the Moffat objections I think Mr. Carroll pushed quite strongly for some form of oral hearing at the last meeting. And it's acknowledged, sir, that you may feel that that would be appropriate in the circumstances, albeit for the reasons that we've set out previously. A hearing would be much preferred and much more efficient. And I would be happy to address you further on that point, sir, if required. But yes, so far as the other objections are concerned, not related to the question of alternatives, it does seem to the acquiring authority that the use of written submission would be the most appropriate and efficient mechanism to ingather the evidence or any additional evidence that you might require, as is often done in other CPO hearings, CPO inquiries rather, as I'm sure you're aware, sir. To that extent, sir, if written submissions were to be used, the suggestion relating to statements of case wouldn't be relevant to that. The statements of case would be required where parties were looking to prepare for some form of oral hearing. So if you were minded, sir, simply to affix, for example, a hearing in relation to the question of alternatives, but to deal with everything else by way of written submissions, then I think the written submissions could simply be exchanged with the right to reply, of course, sir, if any issue were to arise during the first round of written submissions that meant that there was some comment required in response.
Okay, thank you. So I'll go to Mr. O'Carroll next in that case. As I say, I recognise there's a crossover of issues there. And certainly at the pre-inquiry meeting in the summer, there was an indication there that there was a sense that there should be either a hearing or a full inquiry in relation to Mr. Dunlop's objection. I think he mentioned 21 days at one point, or that was the collective total of what he thought would be the period that would be required. But Mr. O'Carroll, could you come in on this point as primarily on the non-alternative site objections?
Certainly, sir. The email of 7th of November from Mr. Hamilton that you've referred to, I read that and I was quite surprised to see its content, in that it seemed to want everything wrapped up either by way of written submissions or at the very most by way of a hearing procedure. And standing what I'd said at the earlier pre-inquiry meeting, I was quite surprised that there was no allowance made in that consideration for an inquiry session. So I think the really important point to stress is one of principle. And that what my client is basically facing is the complete cessation of the livelihood that they've built over many decades and generations, in fact, and that therefore they require to have their voices heard at a full inquiry session in the fullest manner possible. And to that extent, they would wish to have inquiry sessions for all of the substantive points that they're given notice of in the letter of objection.
Okay, thank you. I'll maybe move to Mr. Johnson, General Johnson, on behalf of the Muffet. Next, I'm then bringing in Bell Rural on Mr. Taylor's interests on these issues. So, Mr. Johnson, first of all.
We continue to be engaged in constructive dialogue with the applicant, and we are hopeful that we will be able to achieve a voluntary settlement. So our interests are becoming more of a watching brief rather than feeling that we are likely to need to engage in long-term conflict. Let's call it.
Thank you. And on behalf of Taylor, Bell Rural.
Yeah, much the same as Mr. Johnson's comments. We're hopeful to agree deals in the not too distant future. Although I think it's useful for me to be here today to hear what is happening from other sides as well.
Thank you. Bringing Katie Abrahams for the ENGL. And again, emphasising here the non-alternative site issues. I think they had some as well.
Yes, sir. We'd be happy to deal with the remaining outstanding objections that we have by way of written form if required.
Okay, thank you. I'll bring Scott McCallum next for NNG.
Thank you, sir. Just by way of very brief update, NNG have continued discussions with the acquiring authority. We remain hopeful that voluntary solution to the issues faced by NNG is still possible. In the absence of that agreement, however, sir, we are of the view that it may be necessary to have a short oral process in order to properly explain outstanding issues that NNG face, which are of a very technical nature, if indeed the interactions have to take place without any kind of contractual thought. So we would ask, sir, that perhaps a short hearing or inquiry session to explain NNG's interests in the event that we remain in the process at that point would be our preference.
Okay, thank you. Mr. Cox, on behalf of Gordon Van Ainsley.
Much the same as Mr. Johnson, Mr. Bell. Our clients are currently in negotiations, which are fairly well advanced with the authority. But in the absence of that being agreed, I think our objections could be dealt with by writ submission if they were still required.
Okay. And Michael McLean, on behalf of SP Energy.
So similarly to others, the discussions are very much ongoing between SP Transmission and Distribution and the acquiring authority, and the hope is that resolution will be reached soon. And in the absence of agreement being reached, it is our view that the remaining objections could be dealt with by written submissions.
Okay, and Mr. Mitchell for Nuclear Liabilities Fund.
Thank you, sir. Yes, the Nuclear Liabilities Fund's concerns are broadly aligned with those from ENGL. So, like ENGL, we would be content to have any outstanding issues dealt with by way of written submissions as well.
Okay, and Alana Baker for Tarmac Cement and Lime.
Thank you, sir. Yeah, as the others just said as well, voluntary negotiations are progressing between the parties. However, there are a number of technical issues in respect of the impact on Tarmac's operations, which would be considered would be best dealt with by way of a hearing or inquiry.
Okay, that's very useful. I don't know if Mr. McKay wants to say anything further before I try and summarise all of that.
Well, just on the broad issues of whether inquiry or hearing session might be more appropriate in terms of any oral process that's required. And this relates both to alternative issues and other issues. And really as a matter of judgment, sir, but you would need to be satisfied that there were issues of real complexity that demanded that cross-examination was required if inquiry were to be fixed. This is a CPO hearing, and generally speaking, the principle is that the least formal means of is the most appropriate means. And of course, there may be exceptions to that, but none of the parties have actually identified any specific issues or complex issues that necessitate cross-examination, even where technical issues do need to be discussed, sir. As you're aware, there are many examples where hearings are used very efficiently and successfully by reporters, and that's acknowledged in the DPA guidance note 23 on managing an efficient inquiry process at page 4, where it speaks about a proportionate process. And indeed, Mr. Carroll and I have recent experience of being a Section 36, Section 37 Electricity Act application, where some degree of technical evidence was perfectly capably handled by the reporter with some success by Mr. Billia. So in my submission, yes, as a matter of judgment, but in general terms, if there is a need for an oral process, hearings are probably the most efficient and proportionate way of handling the conduct of this particular inquiry.
Thank you. I'm realising actually that I didn't bring Mr. Jimison in on that issue in relation to suggestions other than in connection with the alternative site, but I don't know if he wants to say anything, having heard what other parties have said. Jimison?
Sorry, sir. I'd only really like to add something when we are discussing the alternative sites.
Okay. There's two sets of issues. One of which is whether, to a certain extent, some of the objections can now be addressed by way of written submissions, and those points that are made in particular, but not necessarily only in relation to William Dunlop and Tarmac Cement, require a further procedure. And then the question is whether that's dealt with by hearing or by full inquiry. And obviously it'll play into a certain extent as to the way we take matters forward in relation to the alternative sites issues. I'm conscious that from, I think the email, I think it was 17th October from the acquiring authority, one of the concerns that they were raising at this stage was not just the question of whether these matters should be addressed by a full inquiry or by a hearing, but the question of whether there was an adequate specification on some of the issues arising before a decision is made in that regard. I'm particularly conscious, especially based on what Mr. O'Carroll has said, but also Alana Baker as well on behalf of Tarmac, that although we're progressing to resolution of matters in some respects, it's a clear indication that we're not in a number of other respects. So I am inclined at this stage to require the objectors, particularly those who are seeking to have a further oral procedure, to provide an update and provide as much specification as they can to complement their earlier objection, to give an indication as to where we need to progress and identify those issues, in respect of which the acquiring authority would obviously have an opportunity to comment. And at that stage, it doesn't sound as if there's going to be one size that fits all in terms of going forward. For those who've indicated that they're content to rest on written submissions, then I can accommodate that. But it sounds as if there are some parties who would wish for non-alternative sites consideration for this to go to either a hearing or to a full public inquiry. I'm inclined at this stage to ask those who are seeking further process in this to submit an update of their objection for consideration by the acquiring authority, and then I can make a ruling as to whether, based on the objections that are made, whether that's something that I feel is necessary to be dealt with by a full public inquiry or by a hearing process. If that's to be done, the question in my mind would be allowing time for the equal in council planning consideration outcome to become aware, for parties to become aware of that. What the date would be for asking those who wish to submit a further clarification of their case, for those who wish some sort of oral procedure to follow, as to what an appropriate and fair period to ask them to provide an update of their position as requested by the acquiring authority. I am conscious of time issues. We'll come to that a bit later on, and I'm inclining to suggest for those who are seeking further oral procedure of one form or other to submit an update of their objection by 21st December, which gives a little bit of time after the planning committee makes this decision. Just over a month from now. I'm conscious of Christmas timings. I think that's the second last working day before Christmas. But ask them to submit an update for those parties who are suggesting further oral procedure. I would then look for the acquiring authority to comment in response to that, but it might be quite difficult to say just now how long they would need before having seen sight of what's actually come in, but obviously as expeditiously as possible. But after that, but I maybe invite comments from those, particularly those who are seeking further oral procedure, for any comments on that suggestion. We're starting with Mr. O'Carroll.
Well, thank you, sir. I'm grateful for that. But normally what happens, of course, is I say what I've said and then you make a decision, because the decision is ultimately yours and your discretion. But I appreciate the opportunity given for that purpose, and happy to do that. Thank you, sir.
Okay. And Alana Baker, do you have anything to say about giving an opportunity to update your case by 21st December?
Thank you, sir. Yes, we'd be happy to do that as well.
Does anybody else want to say anything before I go back to Mr. Mackay?
So just on behalf of NNG, we would be also happy to update the case there in terms of the procedure.
Okay, thank you. Mr. Mackay?
Yes, sir. Insofar as parties are seeking oral procedure of some sort, then statements of case from those parties would be very beneficial to understanding what issues are to be canvassed at the inquiry hearing, and provide fair notice of the main lines of argument and main technical issues that might require to be addressed. But insofar as the broader issues are concerned about preparing for the inquiry, the acquiring authority have set out their concerns about the nature of time here, and are looking for a procedural notice which will fix dates in March at some point. I think it's the most appropriate. We'll come on to discuss that, obviously, so I'm not seeking to get ahead in the agenda. But part of that will be understanding what is the most appropriate form of hearing at that time of year. And I say that because some of the objectors, and indeed one of the witnesses, primary witnesses, who might be required if we're dealing with agricultural impacts in relation to the Dunlops, they will have considerations around the lambing season in coming into April. And there's also an issue about Easter break and so forth.
Yeah.
So for practical reasons, it may be that we have a relatively short window of time available to parties. And for that reason, what the acquiring authority are looking for to happen on the back of the discussion today is for you, sir, to issue a procedure notice which fixes dates and reserves those dates on the basis of your understanding of what would be the appropriate form of process. As I say, the acquiring authority's position won't change in that respect, based on the statements of case which are provided by the parties. That's a separate function that relates to notice and fair notice of the issues. In terms of the procedure, the acquiring authority is quite clear that if any oral process is required, then hearing process would be by far the most efficient way to deal with the issues. So that is the acquiring authority's position, sir.
Okay, thank you for that. The one thing that would arise in relation to that all these things are tied together with the nature of the procedure that's adopted, is the question of how long would be needed for consideration of non-alternative site issues. And we had a bit of a discussion about this at the last meeting. We will come to the question at the moment. You're absolutely right, Mr. Mackay. There is a wider question of how the splitting of this way of proceeding impacts on the overall timescale, and I am conscious of the issues of timings and indeed the issues that you raise in relation to finding times and finding dates for all of this. But it might be useful to go to the three parties who are indicating that they're going to be submitting further information, whether they have anything to say at this stage. And I emphasise that it is anything they may usefully be able to say, because it's very, very hard to anticipate what sorts of time periods do they think would be needed for an oral procedure of whatever form in relation to the non-alternative sites question. I'll start with Mr. O'Carroll.
I have taken some consideration to this, and I think in view of the issues that are outstanding, I would have thought from previous experience somewhere in the region of 2 to 3 days would be required. While I've got I was actually about to add in something at the end of when I last spoke with relation to the statement of case issue.
Yes.
And I see that Mr. Mackay has gone and made a submission in that regard. So I would just like to say that as far as that's concerned, it still remains the position of my clients that, well, those instructing me, that it's the letter of objection of the 20th of April 2023 is very full in its own terms, provides the adequate advance notice of all matters that will be raised. And the only matter that's different that will be raised in the statement of case, and therefore be effectively a duplication of that letter of objection, is in relation to the alternative site. And the matter is already known that the site at Oxwell Mains is no longer proposed, but 2 other sites are. With that apart, everything else would remain the same. So I still maintain that it would be unnecessary stage of procedure to add in a statement of case at this stage. Although, having said that, the additional part which will be provided to you, as I said in my last answer, is that further information will be given to you justifying the level of oral procedure that we seek. Thank you.
Yeah, that would be useful. Thank you. Alana?
Thank you, sir. Yes. We would have thought 1 or 2 days would be sufficient for the further oral procedure.
Okay. On behalf of NNG?
Thank you, sir.
Thank
you, sir. We would anticipate half a day to deal with the NNG's
food issues. Yeah. Okay. That's very useful. I mean, in relation to the point made by Mr. O'Carroll, if it is the case that in respect of those instructing him that there's very little to be added by way of an update apart from representations on the nature of the hearing or the oral procedure, then that may allow that to be submitted a little bit earlier than the date I've given. It may well be there's a relatively limited update to be given, and if those who are have requested to give an update were able to do so ahead of that date of 21st December, that would certainly accelerate the timescale and minimise the risk of delay at the other end of the process. Okay, that's helpful from that perspective. It does tie this. We'll come on. We'll come on now to the question, I think, of alternatives, and I will give some thought on the basis of what's submitted as to whether some form of process and make a ruling on which it is can take place at a date that works in the course of the early part of next year. I am indeed conscious, as Mr. Mackay says, of the Easter period. A fair point is made about the lambing season. I'm also conscious, though, in relation to Tarmac's interest, that their counsel, Mr. Burnett, has given an indication of non-availability for that period extending to effectively the first 3 weeks in March of next year, that will have to be accommodated given that they maintain a non-alternative site objection to that. I'll also have to give some thought, depending on the timings of when these responses, these further updates of cases are received and what the acquiring authority then decide to do, or what they say in response to that, after what that means for giving an adequate time period beyond this exchange of documents to give proper time to prepare and produce documents ahead of an oral procedure addressing these issues. So I will give thought and continue to give thought to that once I've heard those further representations. Okay, moving on then now to the question of alternatives, and there's a number of issues that arise here in relation to that. Obviously, as I said at the start of this meeting, I've seen the acquiring authority's note and Mr. Jimson's email from last night. I should say to Mr. Jimson, I know he was saying last night that he was hoping that he hadn't misled or confused anybody by the map that he produced, the plan he produced. He should not worry about that. It was very helpful to see that. I suspect what the acquiring authority will say is that some of the issues arising in relation to the land beyond the site that he's proposing, those issues will still arise, even if his sketch indicating the area identified may end up being potentially a smaller one. So no need to apologise, but Mr. Mackay, I suspect, will be making representations in that respect just in a moment. In relation to the question of alternative sites, there are two sets of issues in my mind here, both of which are flagged up in the agenda for the meeting. One of which is the process of giving notice of possible alternatives, and the other are the substantive issues of how we go about the question of identifying those and assessing those. And I'll turn first of all to Mr. Mackay for the acquiring authority. I'm not looking to him to go through in detail what was sent on behalf of the acquiring authority yesterday, but nevertheless, if it'd be useful if he could summarise his position in all of these regards, and then we can take the views of other parties. Thank you.
Yes, thank you, sir. May I take the note that was circulated as read, and just in summary, there are a number of reasons why, on balance, the acquiring authority are asking you to exclude or refuse to admit the later alternative suggestions made by the Dunlops and Mr. Jameson, and for various reasons. Too late being a primary reason, too imprecise. They're not truly alternatives to the scheme that's being promoted. Thirdly, there's no attempt to support the alternatives by any reasoning which would suggest that the clear analysis presented in the Environmental Impact Assessment Report chapter on alternatives is wrong in some fundamental respect. Fourthly, as alluded to in the note, there could be significant procedural implications relating to third-party interests. And lastly, sir, partly because of the late raising these issues, it relates to the question of a potential credit, in particular, especially in relation to the alternative suggested by Mr. Jameson, which relates to an area that hasn't been studied in any great detail for the obvious reason that it's within the nuclear licence area, and therefore it just isn't practical or sensible in any event. So there are lots of different reasons which, as I say, are set in more detail in the note. And just on a practical issue, sir, it's made clear that my instructing solicitors are carrying out further inquiries as to potential land issues, but we would need to provide an update if you were minded to allow these alternatives to be considered in some way or other, because you wouldn't necessarily have to fix an oral hearing in relation to these issues. They could also be dealt with by way of written submissions. But the note makes clear that there would need to be further inquiry in relation to potential third-party interests.
Okay, thank you. And Mr. McCarroll, on behalf of William Dunlop.
Thank you. I'd like to refer to the note that has been provided. And there's some points about it that arise that I'd like to draw your attention to.
Sure.
Under the Dunlop and alternatives heading, there are a number of bullet-pointed paragraphs. And it says, incomplete alternatives cannot be said to be reasonable alternatives. And then there's also mention made in the next page in that same bullet point of sufficient details being required by Rule 6. Can I draw your attention, please, to Rule 6? And if you don't have it in front of you, I can read it out.
I do, but read it out anyway for the purpose of benefit of others.
And Rule 6 says, where an objection duly made or a statement of case shows that a person proposes an alternative site for the purpose envisaged by the order, that person shall provide him, the Secretary of State or the ministers, with sufficient details of the proposed alternative site to enable it to be identified, and shall at the same time send copies to other parties. So what you have in the note is a partial quote from the rule. The sufficient details that are required are to allow the site to be identified. What has been produced is an alternative site map with the sites clearly identified on a map, one of them being described as the Dunbar Works alternative area and the other one being the Torness Power Station alternative area. So contrary to what has been suggested, Rule 6 has been complied with. And I would also state then that in terms of suggesting those alternatives, that is as much as requires to be done. It is for the process of the CPO inquiry to then assess those with arguments from both sides and to find where the interests lie and whether or not there should be acquisition compulsorily or some other lesser form of acquisition or the means by which that can be done. It's not at this stage, at these very early stages of the inquiry, here we are then second pre-inquiry meeting, to provide a complete and comprehensive technical application for why an alternative is suitable for the acquiring authority to use for its purposes, which the acquiring authority itself knows very, very well, but in fact is more of a mystery to those people acting outside the confines of the inquiring authority itself. So with regard to that, then what I would say is that what is desiderated on behalf of the acquiring authority goes far beyond what's required by the rules and what is required in terms of adequate advance notice. In terms of the EIA, there is a saving provided in the page 2 of that particular note provided to you ahead of today, and there are certain points made in favour of admission of the identified alternative sites for consideration, albeit late. Well, there are 5 bullet points made in that regard. They're not being made by me, they're made by the acquiring authority itself. But the EIA is one thing, but the inquiry is quite another. And it's for you as a reporter to consider all of the evidence and whether or not the alternatives suggested actually are realistic alternatives. And insofar as the alternatives impinge on land ownership by 2 other landowners mentioned, well, that's in the nature of it. Land is always owned by somebody. And so whether it's the Dunlop's land that should be compulsorily acquired or some other interest that should be so acquired is a matter for resolution in the fullness of time after the evidence has been heard by you for that purpose. And what has been provided so far has been quite adequate for that purpose. And you have the alternatives on a map. Thank you.
Okay, thank you. I'll now move to Mr. Jimmison, as the other party suggested an alternative for his comments in response to the note that was circulated yesterday and what Mr. Mackay said this morning.
Thank you, sir. I'd like to pick up on Mr. O'Carroll's points. I am of a similar view. I believe that I have indicated an alternative site for consideration. Indeed, I would also support that what is termed the Dunlop land, the Dunlop site or proposal is also included in addition to my red area for consideration. One of the pushbacks that came in the note was that, again, building on Mr. O'Carroll's point, that I hadn't detailed cable routes and things like that. I am happy to do that, but I would also point out that I do believe that indeed the acquiring authority already has alternative cable routes in addition to that that are being talked about under the CPO process. So there has been a lot of work done, a lot of optioneering work that has been done by the acquiring authority that was not made public and has therefore, I believe, been unclear on what options could have been considered, and for their own reasons, the acquiring authority has chosen to site their proposed substation on Dunlop's land and chosen a particular cable route, where there are alternatives that they have already discovered and assessed themselves. So I'm not particularly asking them to overly do a whole lot of new work, but I am more than happy to expand upon the rationale and the thinking behind my thoughts. Indeed, I'm happy to do that for the 21st of December, if that suits.
Okay, thank you. Can I bring in Katie Abrahams for ENGL, as representing a party whose land will be impacted by one of the proposals?
Yes, thanks, sir. As I think we've communicated, we continue to support the principle of the acquiring authority's proposed development, and we have in the past engaged with the acquiring authority regarding the potential use of some of the ENGL's land for an alternative. And as has been detailed in the acquiring authority's alternatives report, that land was deemed by the acquiring authority to not be suitable. The rest of the land that is being proposed by the 2 alternatives falls within the nuclear site licence boundary, as has already been identified last night and this morning by the acquiring authority. And so I think for fairly obvious reasons that would be problematic, and as such we don't consider that to be a viable alternative.
Okay, thank you. Can I bring in Anna Baker for Tarmac Cement? I'm not hearing you just now.
Sorry. Thank you, sir. Yes, Tarmac proposes the submission of the Dunbar Works Alternative Area site as submitted on behalf of the firm of William Dunlop on the 2nd November, provided reporter on the 7th November. So Tarmac submits to the reporter that the alternative site should not be emitted late. It's far too late to be raising an alternative, and this would cause substantial prejudice to our client. However, if the reporter is minded to allow the alternatives, this particular alternative into the process, then we would request that the reporter provides for further procedure, so that our client can expand upon the reasons for opposing the alternative. And we also think that it would be beneficial to the reporter to have our reasons as to why this site would not be acceptable. Secondly, our initial title review identified a number of interests in the land over this alternative, in particular over the Dunbar Works alternative area site. It is owned by Tarmac, however, there does appear to be a number of other interested parties to the site. And thirdly, we would just highlight again that the Dunbar Works alternative area site is safeguarded under planning policy for the continued extraction of limestone.
Okay, thank you for that. I see Mr. Jimson's got his hand. I'll bring him just in a second. The other thought that come to mind in relation to looking at the Tarmac site, and I say this for Mr. O'Carroll's benefit, if we decide procedures going forward from now, I'm conscious that for those who attended the site visit on 28th of August, there was a tour given of the Tarmac cement and lime site, and it was explained that there was an area of land east of where the current excavation and quarrying is going that will progressively be used as time goes by, moving into what looked like the site identified as a potential area for an alternative site. So I just flag up because I'm conscious that not everybody was represented at the site visit, just to note that was what was explained to me and was set out at that site visit, and that does appear to relate to some of the land identified in the proposal site, even though when you look at it now, it's not a site that is at present quarried. So I just record that as something that arose for the benefit of Mr. O'Carroll in particular. But Mr. Jimison, you had your hand up.
Yeah, thanks. Just the briefest of responses to Ms. Abraham's comments there. I am actually aware that my red line suggestion is within the nuclear licence site. I am fully aware of that. This forum that we're having this morning perhaps is not the most appropriate place, however, to this, for perhaps me to glean why you have stated that should preclude my suggestion just because it's a nuclear licence site. My understanding as a long-term resident is a lot of that was future-proofed for Torness 2. Torness 2 is clearly not going to happen, and therefore I perhaps in another time or by writing I could seek clarification as to why either yourself or others may be attempting to preclude that for consideration.
Okay, thank you. I'll come in a second to the question of what we do by way of next and further procedure. And there's two sorts of issues in my mind in relation to the question of the assessment of alternative sites, and as Mr. O'Carroll rightly points out, the Rule 6 of the inquiry procedure, compulsory purchase inquiry procedure rule, directs at least some discretion to the reporter in deciding how matters are to be progressed. And I appreciate that in the original objection by William Dunlop, there was a reference made to alternatives in their objection back in April. The issue does come quite late in the day, in the sense that when we had the pre-examination meeting, pre-inquiry meeting in June, a reference was made to a possible alternative at one not being pursued. So we have a situation where we are a considerable period down the track and having to make decisions about the next steps. And so I'm conscious that whatever we decide to do is going to be potentially quite challenging in terms of the expeditious progress of the examination. That being said, it is nevertheless the case that my role is to provide the best recommendation that I can to get the proper outcome in relation to this acquisition, and not in terms to fall within what works for the acquiring authority for its own sake. We need to carry out a proper examination of this, and if that means spending time looking at alternative sites, then so be it. On the question of notice to affected people, Rule 6 of the inquiry rules in this respect don't, in their own terms, envisage public notice being given of exactly the same form as if set out in the Acquisition of Land Authorisation Procedure Act 1947. But there are various aspects of notice that are required to be given where a person's land is impacted upon, one of which is actual notice to the affected person, identification and given notice of people whose interests are affected. The other is a public notice, and the other aspect contained in 1947 is a site notice, which might actually be relevant here if the acquiring authority's information is correct that at least one of the sites concerned has an unidentified owner. So there's a complication in relation to that if that ends up being correct. I'm grateful for the work that was done by the acquiring authority in indicating to me yesterday the current ownership position in relation to alternative sites. I am anxious, though, that we can collectively ensure that steps are taken to be entirely satisfied that everybody who has an interest, whether it be an owner or certain occupiers who would normally be served with a compulsory purchase order, has been identified and has been given notice of the possibility of a consideration of this alternative before we get into the substance of all of this. My question, this isn't really particularly answered by Rule 6 rather, is the question is whose responsibility is that to do? And so I'm grateful to the acquiring authority for having kicked the process off. But I look here mainly to Mr. O'Carroll rather than Mr. Jimison, because I realise Mr. Jimison is not legally represented. But I'm really looking to get a sense from parties as to what is necessary to be done purely in terms of giving public notice, mindful of the need to keep a reasonably clear constraint on timings of the procedure. I think I'm going to require, before I can report to Minister, a reasonably clear indication and a certification from somebody. And the certification may well require to be from somebody as a solicitor or otherwise able to certify that all parties with a property interest in the land identified, and this, as has been identified, goes beyond the ownership of VNGL and Tarmac, because other interests have been identified in relation to this. I'm going to need to be satisfied that proper notice has been given. And my question, I guess, is how is that to be done, by when and by whom? My starting point would have been that it would be those promoting the alternative who would take those steps to ensure that I can report on the basis that everybody who has a land interest affected by this has received notice. And a question might arise as to whether, I think this is perhaps ultimately not for me, it might be more for William Dunlop and Mr. Jimison to worry about, whether there's a need to go quite as far as the 1947 Act would require, had these sites been identified at the start, for public notice. The risk, if for example, newspaper advertisement, if that's not done, to a certain extent, that's a risk run by the objectors if I were to recommend the pursuing of an alternative notice. But the difficulty is that ministers may take a different view when they get advice in terms of what notice has been given more publicly of the existence of this. So my inclination is to say I need a little bit more, I need to be satisfied a little bit more than I am just now, that all the interests that are beginning to be identified in relation to these areas of land that are subject to the alternative site are identified, and that notice has been given effectively formal notice as if this was being done at the start of the CPO process, so that I can proceed with confidence that there are no other potential objectors to the alternative sites that may well emerge to part of that process. And as I say, there's a related question as to whether a public newspaper notice would be required and who's to do that. So my inclination is to say that somebody, and my first reaction would be, it would be those promoting the alternatives, need to take steps pretty quickly now to be identifying or confirming and giving notice on those people who have an interest, and then certifying to me that that's all been done. I appreciate that timings are getting tight if I were to progress with this examination as quickly as possible, but I'm also conscious that the issue of alternatives was raised in the pre-examination meeting on 30th of June. The only one that was mentioned has now been abandoned. So we're nearly 5 months later, and I'm hearing effectively ahead of this meeting for the first time that there are serious suggestions of an alternative site. I should also indicate, and parties may want to express a view on this, is I've noted what the acquiring authority has said in relation to alternatives having been contained and assessed in the environmental impact assessments that have been lodged. I'd remind objectors, as long ago as August, I wrote and asked that if anybody wishes to rely on any aspect of the EIAs, they should intimate that within 14 days and make those representations, I think from memory, by the end of September. If any objectors were wanting to take issue with what the acquiring authority are telling me was contained in relation to alternative sites, they had that opportunity in August and September to say that they sought to address those issues and didn't do so. So I am concerned at the lateness that this issue has arisen. But I maybe first of all, I'll go to Mr. O'Connell. Mr. O'Connell, beg your pardon, on the basis that it's his clients who are promoting this. What are the steps, and is it for your client to carry out those steps to ensure a proper title examination, to clarify and get to the bottom of who has an interest, and then intimate those issues, and by when?
I'm just going on the basis of Rule 6, sir. And Rule 6, as I've already set out in part, requires the Scottish ministers, that is you, to be provided with details of the proposed alternative site to allow it to be identified, and to send a copy of those details to any person on whom statement of case has been served. Well, that would be the other parties who are present in the current proceedings, having been served, I presume, by the acquiring authority.
Yeah.
It then goes on at 6.2 to say where details are provided to the ministers under paragraph 1, he, as in they, the ministers, shall give notification of those details to any owner of land comprising the alternative site as they think proper in the circumstances. So I think that the burden on notification falls clearly and squarely on the ministers, as in the ministers through you as the deciding authority, the determining authority.
Yeah.
And the method by which that would be done, to answer your further questions, the method by which it says as you think proper in the circumstances. So you've made reference to the 1947 Act, and that there would be a question about advertising. That's certainly one way of doing it. You might be satisfied on the basis of what has already been represented to you and the parties that are already part of this. These proceedings at the moment have been convened so far that is adequate, but that's a matter for you on what you consider to be proper in the circumstances. I don't think it says anywhere there's any suggestion that there is a burden on the party promoting an alternative to undertake the requirement to identify those other parties and to notify them, other than what has been stated in Rule 6.1.
Okay, can I bring in Mr. Mackay on that point?
Yes, sir. Clearly, Rule 6 says what it says, and I mean, coming back to the submissions that Mr. Carroll made earlier, the whole point of Rule 6 is to ensure that other landowners who might be affected by the suggestions of alternatives being made by objectors are given notification and are able to participate in the process if they so wish. And in that respect, sir, Mr. Carroll's submission earlier missed the point completely that was being made in the note that was provided yesterday, which was that the alternatives are only alternative substation sites. They're not alternatives for the purposes envisaged by the order, which is the precise phrase that's used in paragraph 1 of Rule 6. Where an objection duly made or a statement case shows that a person proposed an alternative site for the purpose envisaged by the order, that person shall provide sufficient details. So sufficient details would require not just the substation site, but actually an indication at the very, even if on a high level, an indication of the route that would be taken, which would connect the substation site to the grid, which is the point that was canvassed in the note that was provided yesterday by the acquiring authority. So that raises a practical consideration that you would have to take into account, sir, as to whether at this stage in the process it's appropriate for objectors to raise late other alternatives which cause this procedural difficulty, as detailed more in the note itself. So I don't take issue with Mr. Carroll's reading of the rule. What I'm doing is highlighting the purpose of the rule and what is required to achieve by way of notification.
Okay, I'll bring in Mr. Jimison on this particular point of notification to people who might have another interest in any of the land, either directly affected in the proposition or in land leading to that.
That will be a challenge for me, sir. There's no doubt about that. However, just picking up on Mr. Mackay's point there, I am more than happy to attempt identifying cable routes, some of which I do believe, and will state again, have already been investigated by the acquiring authority. So I obviously can't do anything here and now today, but I will endeavour to furnish yourself, sir, with the best possible quality information I can, without trying to hoodwink you or tell any untruths.
Okay. And Mr. Carroll, the difficulty that I would have right now with how you've expressed what the duty of myself on behalf of ministers would be is that I'm not really yet in a position to satisfy myself that I know exactly who notice should be given to. This is obviously a very recently arisen issue. I don't have a certification, and I don't expect this from Mr. Jimison, and I'm sure the acquiring authority will help him out as far as they reasonably can. I don't have any indication of a comprehensive nature of whose interests are comprehensively and thoroughly affected by all this for such notice to be given. So I'm in a slight catch that even if I agree with your proposition, this is for DPA and myself to give notification to all interested parties, how do I identify those interested parties? Is it my role to carry out some title examination and to check the title sheets of these areas without assistance from parties? Or am I entitled to seek assistance from parties, including those principal landowners who are represented today, and who therefore his interests are less prejudiced because they're here involved in the process, in order to take matters forward? It does seem to be something of a difficulty, but even if the role is mine, that I can effectively do that unless parties furnish me with the information in a comprehensive and certified way that can allow that to happen. I'll look to Mr. Carroll first.
See a difficulty, but I'm not. The alternative, as you're suggesting, would be for the objectors to then carry out an extensive title search for you to then take forward, and that would increase the financial burden on them in taking forward their objection, which they're doing on perfectly legitimate grounds, and that's not what the rule requires them to do.
Yeah, it's your proposal. It's your client's proposal.
Yeah, but that's what the rule says, though.
Mackay? If Mackay has anything to say on that.
Yeah, you're quite right to raise this practical issue, sir. and there's no doubt that it's the lack of thought that's been given to the consequences of the alternative substation location that's causing that issue. So far as the acquiring authority is concerned, however, obviously it would want to avoid any procedural hiccups that might cause further delay. So, and in general, the acquiring authority would do what's required to support you in the process anyway, sir, to assist you in the smooth handling of the inquiry. So if you are satisfied that these objections are in relation to proposed or suggested alternatives should be allowed in, then providing there's clarity from you as to what we are asked to do, we'll follow through any title searches or make any inquiries that are necessary, and assist in providing notification and so on. But as I say, the first issue is, as a matter of principle, should they be allowed in at all? And for the reasons that are set out in the note, that the acquiring authority submits that on balance, accepting some of the points that have been made by Mr. Carroll and others, on balance, I think perhaps ask Mr. Hamilton to come in with any additional thoughts which he may have on what I've just said.
Yes, please. Thank you.
Thank you, sir. The acquiring authority, as Mr. Mackay has outlined, would be happy to assist you in any way you deem necessary in relation to notice, but it is critical we know where searches are to be conducted. Obviously, we have the alternative sites at the moment, but as Mr. Mackay has outlined, we also need to know what routes in and out of those sites would be in order to get to and from the grid and the wind farm, and searches would need to be conducted over those, and we don't currently have a picture of where those should be. But in general terms, we would be more than happy to assist in any title searches.
Okay, thank you. I'm grateful for that. The issue, as Mr. Mackay says, is an issue of principle as to what's to be done in this context. And it does strike me, in addition to everything else, that one of the issues that has arisen since these matters were raised of the possibility of the alternative site is I'm conscious that when originally raising this issue on the 7th of November, the acquiring authority through their agents referenced the possibility of alternative sites and suggested a timescale, and in particular at that point, suggested a timescale that any alternative sites should be identified within 7 days of this pre-inquiry meeting. It slightly surprised me that they took that view, but that did nevertheless imply, at least, that they weren't necessarily objecting in principle to alternative sites being brought forward. And indeed, in response to that email on the 7th of November, I, through my case officer, asked the parties if they had other alternative sites not yet at that point identified, that they should be indicated to me effectively by return. And that was done on the basis of the indications given on behalf of the acquiring authority. It's fair to say that Mr. Jimison did exactly what I asked of him. He then, within 24 hours, had come back with his proposal. So I am conscious that to that extent, there didn't seem to be any particular objection in principle by the acquiring authority or further exploring.
If I may respond.
Yes, of course, absolutely.
To make clear the context. The context was that despite the earlier ruling that you'd made in June, there hadn't been the clarification confirmation from the Dunlops as to their suggested alternative. For that reason, I asked agents to pursue that, and after further delay, it transpired that the actual alternatives which the Dunlops were now canvassing were different to the one which had previously been mentioned. So for that reason, there was uncertainty in the mind of the acquiring authority as to which alternatives were to, if any, are to be considered an inquiry. Hence why in the procedural email, it was suggested that clarification certainty was required following this pre-inquiry meeting. It wasn't an indication in principle that all alternatives were acceptable. Now that we have the further emails from Mr. Jameson, further clarity from the Dunlops, it's entirely appropriate for the acquiring authority to express a view as to what the implications are on a procedural level, and for the reasons which have been stated in the note, you're being asked to reach a particular view, or indeed to disagree with the position of the acquiring authority, allow the alternatives in some way, but to manage that as part of the inquiry process, either by use of written submissions or a focused hearing session in relation to the relevant issues.
Mr. Carroll, do you have anything to say on that, this issue?
Nothing further to add at this stage, thank you.
Mr. Jimison?
Nothing further to add, sir.
Okay, thank you. The issue of notice is going to be a problematical one, but it's obviously secondary to the issue as to whether an opportunity to explore these alternatives should be given. I'm inclined not to rule out the alternatives being received into process by way of a ruling today. I will, though, make a ruling on that at a later appropriate point. I think it's appropriate now, because of all what's been said, and including what Mr. Jimson said about his proposal, that we need to set a timetable, and fairly strict timetable, for proposals on alternative sites. No doubt for Mr. William Dunlop, that'll be a proposal linked with why the CPO should not proceed on their site, as well as why the alternative site is suggested or proposed. As far as Mr. Jimison is concerned, he doesn't have any direct impact on land owned by him. So from his point of view, he'll simply need to explain why the alternative site, which I think he understands, should proceed. And parties should nevertheless be entitled to make those further representations. But it is nevertheless clear, as far as those promoting the alternative sites, but what correspondence has shown us in the past few days is that they are now on clear notice, certainly of the problems that have been identified both by Tarmac and by ENGL after the issues with the sites that they are seeking to have explored by way of an alternative. We know what the acquiring authority have indicated, are said in terms of at least part of the answer in the EIA in relation to alternative sites. Now, the points made today that is not regarded as a complete answer, but is nevertheless, there's information in the EIAs there about alternative sites that those promoting those sites will require to address. There are other consequential access issues that those promoting the alternatives will need to address as well. And as I said, there was an issue raised at the site visit on 28th August regarding the impacts on the Tarmac site. So I think that it's necessary on that basis, on an interim basis at least, to require those promoting the alternatives to lodge a statement of case, giving a specification of what those alternatives are, in light of the information that's been provided by the acquiring authority through the note yesterday, and by other affected landowners that's been made available to this meeting this morning. This, I think, has to be done pretty quickly. What the impact on notice to others, what that means, may well be required to be addressed subsequent to that. But I'm inclined to suggest that a statement giving further specification and addressing the detail that would be required as a precursor to an examination at an oral procedure should be lodged on behalf of William Dunlop and with Mr. Jimison by the 8th of January 2024, give you a little bit more time than in relation to other matters. And then the acquiring authority would then have an opportunity to comment on that, as of course would the affected landowners identified in this process. At present, it may well be at that stage that it's possible to reach a decision on who else requires notice to be given of the proposals. Some have been identified already, and I'm grateful for the indications by the acquiring authority of a willingness to progress to that effect. But I think it is necessary, even though this is late in the day, hence a relatively short time period in Christmas intervening in all of that, that I will make a ruling at that point once I've had the submissions on the alternative sites and heard what the acquiring authority and the landowners identified say on whether the alternatives ought to be examined at a further procedure. And I'll do that at that point. If it is the case that these matters are to be examined through further procedure, my first instinct, and I would welcome views from those involved in this part of the process, would be that this, regardless of the non-alternative sites objections, this would be an issue that I think they would have to be addressed by a full public inquiry rather than a hearing. But again, I'd welcome views from all of those who have an interest in this. I'll start with Mr. Mackay on that, and then we can look in terms of what that means for the timetables beyond that.
Well, sir, without understanding exactly what technical evidence might be led and therefore what scope there might be for formal cross-examination, I don't think you can form that view on my submission as yet. It's a matter for you in due course. But you know, for the reasons I've already advanced, it seems to me that in terms of the relevant paragraphs from Circular 6 of 2011, and I won't take you to slides of further reading. Footnote 35 sets out the circumstances where an inquiry is often considered to be appropriate, and where hearings may be more appropriate. I've already mentioned page 4 of DPA Guidance Note 23 on what's an appropriate process, and also recent experience in inquiry procedure, and indeed in relation to CPO hearings and inquiries, whereby, as I say, the general principle these days is that the most amenable procedure for the parties is the most appropriate. And bear in mind also, sir, that the number of the objectors who are expressing a potential interest in this are hopeful of resolving issues with the acquiring authority. So the actual scope of the objections that would be considered in due course isn't all that clear at this stage. But if it's the case that some technical evidence is required, there is no reason at all why that can't be done by way of a hearing. It's a much more efficient way of conducting business and in gathering evidence around the table. That means that parties can still contribute themselves, or they can do so through expert witnesses. It's just a different way of doing it. It doesn't diminish the quality of the evidence that was required to be prepared and submitted in advance by way of any technical report or expert report or anything of that sort. It's simply the way in which the hearing itself is conducted. That's the only real difference in principle or in practice. And Mr. Carroll, myself and Leonard Jr. were involved in a recent inquiry where relatively technical issues were dealt with very efficiently through a hearing process. So it dealt with as a generality. My submission is that for lots of different reasons, but primarily, or at least to some degree, to do with the timing issue, a hearing makes sense. And in any event, sir, there's no clarity or substance before you at the moment, which would explain from the objector's point of view why it is that full inquiry process would be required. It's not simple. It shouldn't be treated as simply as a default in relation to any inquiry, but particularly not in relation to a CPO process, in my submission.
Thank you, Mr. O'Carroll. Both on the date of 8th January to make a representation in detail on the basis of the knowledge your clients now have in relation to the information that's been made available in the past few days, and if you wish to at this stage, representations on the form of the hearing.
Yes, so I understood the deadline for the 8th of January. I'm inclined to go with your own initial thoughts that an inquiry session would be appropriate.
Yeah, Mr. Jimison, you probably don't have a view on the form of the procedure, and I realise it's difficult for you not being legally represented, but this 8th of January date seemed like a reasonable one from your point of view to expand upon your reasoning why you think an alternative site is appropriate. You're on mute just now still.
Apology. Sorry about that. Yeah, 8th of January is absolutely no problem. I'll furnish yourself and others with something as comprehensive as I can make it.
Thank you.
Can I, sorry to interject, sir, but can I ask Mr. Hamilton to just contribute to the discussion here in terms of notification and timescales? Because I think he has a concern relating to the timing of statements of case on the question of alternatives, just to make sure that everything was done in time for inquiry dates.
Yeah.
Yes, sir. Thank you. Just thinking ahead to identifying affected interests other than landowners who are currently present. If notice is to be given to them, then one would expect they would have a notice period, perhaps of 21 days. And if statements of case are not to be lodged until the 8th of January, and then we might take some time to conduct the title due diligence. Once that is done and notice given, we could be well into February by the time affected parties are even at the end of their notice period. So if possible, the acquiring authority would ask that those statements of case are as early as possible.
Okay, thank you. I understand that, and it is an issue that's certainly in my mind thinking about discussion today. And I do appreciate that this is quite late in the process to be addressing these things from the objective point of view. I am doubtful, though, whether it's realistic. On date would gain an awful lot by setting a target date ahead of Christmas as opposed to after the Christmas period. Sadly, or perhaps happily, over the festive period, businesses tend to close down to a certain extent. And the difference between the 21st of December, which is the date I've mentioned for other purpose this morning, and the 8th of January, always seems like a long time, but actually, in terms of business days, is not a huge length of time. And I'm conscious that a period has to be given to the objector to draw that information together. I am rather hoping that even if notification can't be given to other identified landowners or persons with an interest, we should by that stage at least be at the point at which we know who they are, even if no notice has yet been given. The advantage of the 8th of January date is that notice can then be given not only of the order, not only of the alternative, but the reasoning behind the alternative at that point. I agree and accept that that will potentially have an impact on the time period from the point at the beginning of January whereby the acquiring authority required to be given the opportunity to comment as the other affected landowners identified and present at this meeting are too. That ties into the question of when an oral procedure, whatever I happen to be, would be held. I'm going to come to the other parties with an interest in a second, but I was conscious of the fact that Mr. Burnett's non-availability from 26th of February to 22nd of March, but also kind of Easter periods, means that in relation to alternative sites, whatever oral procedure is ultimately proceeded with, if indeed these alternatives are permitted into process, are going to be getting into end of March, beginning of April, possibly second half of April. Anyway, so the knockback period of giving notice to parties that the acquiring authority can identify, hopefully within a similar timescale to the submission of the from those who are suggesting alternative sites, should coincide with that. I agree. Notice, and I think a period of three weeks is probably a fair period of notice. It may well be nobody comes out the woodwork and objects. That it's certainly possible that they will, but we'll then know by the middle of February. And if we're talking of an oral procedure by the end of the second half of April, then that'll be one that would hopefully give those who emerge from this process of identification an opportunity to be properly heard. So Mr. Hamilton makes a fair point. I don't think, if the reality is, others may take a different view, if the reality is that any oral procedure is going to take place in the second half of April, I'm hoping that that would give enough opportunity for those who might emerge out the woodwork as potential objectors to state their objection. Where they might be tight for time is if they wanted to lodge documents in support of their objection. and then matters might begin to get tight for time. But it may be that it's not really possible to be fixing dates until we get into the new year, and that will begin hopefully to coalesce a degree of understanding of what these objectives may say. So I think there is a bit of juggling to be done. But I'd like to bring in Katie Adams and Alana Baker, because they also have an interest in all of these issues too. And they too will have obviously an opportunity to see and respond to what the proposals by way of alternative sites are. But if we could bring in Katie Abrams first.
Yeah, thanks, Sarah. I think it's difficult at this stage without having seen the statement of case of Miss Jameson and the firm of William Dunlop to understand the level of ENGL's involvement in any oral hearings and what evidence might be needed. So I would have thought that hearing procedure would be adequate if we were pursuing an oral process, but I think I'd have to reserve our position until we actually saw the information put forward by those promoting these alternatives.
That's helpful. Thank you. Alana Baker.
Thank you, Sarah. Yes, as noted earlier, we would be looking for, or Tom might be looking for the procedure to discuss the alternatives, I think probably in the form of a hearing, so our client can expand upon the reasons for opposing the alternatives and also why the client doesn't think that the alternative site's acceptable.
Okay, thank you for that. And I should emphasise, as I say, although I'm not making a ruling today in terms of the acquiring authority's motion, without these alternatives, I will have to make a ruling at that, on that matter at an appropriate point, and obviously when I'm more fully informed as to what the detail of what those alternatives are, but whether it be after 8th January or whether it be a date after that, will be a date at which I'll have to make that decision, and at that point we'll then have to reconsider the question as to the nature of the process and the timings of that process. That actually may be, I'll talk about site visits, but that may be a relevant point at which to raise the question as to whether we should think about a further pre-inquiry meeting sometime in January, or whether there's so much uncertainty as to what we're doing that we should maybe just hold that idea and gather together if needs be, rather than necessarily fix a date just now. I'm seeing, before I go around the main part, as I see Fraser Mitchell's got his hand up.
Sir, thank you. Sorry, this is just a very small point just to say that, and it's really just for noting that, as mentioned before, the Nuclear Liabilities Fund have got comparable interest in the site that's been suggested as an alternative, as they do over other areas of land. So it was just to note that we're aligned with what ENGL said, and would like to reserve our position also in terms of what the statements of case may say when they arrive either late December or early January.
Okay, thank you. That's very helpful. A useful reminder that others have an interest and may have opinions on these topics as well. So on the question of another pre-inquiry meeting, Mr. Mackay.
Sir, it does seem to me that on the basis of today's meeting, there are quite a few issues that are still live procedurally, and therefore I think it's probably sensible to make provision for a further, but hopefully final pre-inquiry meeting. I am, of course, urging you, sir, to fix dates for hearings, whether that's mid-March as the Acquiring Authority would prefer, or into April as maybe more practical in your own mind, sir. But either way, we need to plan ahead. We need to have dates for the inquiry, and in the lead up to that, to those inquiry dates, those hearing dates, it may well make sense to have a further procedural hearing.
Thank you. Before I go to other parties, can I just go back to Katie Abrahams just for a second there? I've got the note of unavailability of Mr. Burnett from the end of February to the 22nd of March. There's a question in my mind thinking about the alternative site objections and the other various objections. Would your preference, your client's preference, be that we avoid those dates for all purposes, or might it be possible to set a process or hearing dealing with issues other than alternative sites within that period and progress with an alternative form of representation, or what otherwise would your client's preference be?
I wouldn't expect that ENGL would need to attend any other hearing, because our representations, our outstanding objections can be dealt with in written form, as I think we noted at the start of the pre-inquiry meeting. So if there were matters that didn't involve ENGL for which an oral hearing were required during the period of Alistair's unavailability, then I don't think that would prevent the holding of any hearing or inquiry during that time period. But if it was a matter that went to, for example, these proposed alternatives, if it was deemed that they be allowed, then obviously we would need Alistair's availability during for any matters where ENGL were required to attend.
Thank you. That's very helpful. Any other views from any parties, at least on the principle, rather, and not necessarily the actual setting of a pre-inquiry meeting again in January? If anybody has any views, Mr. O'Carroll, looks as if you're about to speak.
Unfortunately, just stop.
Of course.
I think that would be a sensible thing. As Mr. Mackay says, there are a number of procedural matters up in there. We need to see where we are. I would suggest a week starting the 22nd of January. We certainly be in a position to know then where things are. And just while I'm on the question of dates, I also am in an inquiry for March until the 22nd of March also.
Okay, is that also 26th of February to 22nd of March? At the same day, isn't it? It may or may not be the same inquiry.
For different inquiries, but I've got unavailability between those two dates, 26th of February to 22nd.
So you two are in that position. Okay, that's very helpful.
Sir, I think it's accepted these days, not only within DPA, but even on the part of the bar, that the availability of counsel isn't necessarily a reason not to change plans or to fix inquiry dates.
So, sorry, Mr. Mackay, I understand that.
But even at that, sir, it does look as though the last week in March would be an appropriate window. If you're with me on the principle about the appropriateness of hearing sessions, we could fix dates for the last week in March to endeavour to wrap up the evidence before what I understand to be the main issue about lambing. If we're involving agricultural impact issues in hearings, then that's potential issue. But if that's to be dealt with by written submissions, then that issue flies off. But there are other witness problems as we move into April, which would be best avoided if we could, if at all possible, have the hearing the last week in March, if that's available to the main parties and main representatives.
Okay, that's useful. I mean, it may depend to a certain extent whether we have two sets of hearings, one in alternative sites and one in other issue, and that's often not yet resolved. If you've two sets of issues arising, and there's only one last week in March, there might be an issue around that, but a point nevertheless made, well made and understood. So, well, Scott McCallum's hand up.
As the inquiry authority has said previously, its view is that 4 days in total would be required. So, for example, 2 days on alternatives and 2 days on all of the other issues. Okay. That should be sufficient if hearings are used.
Thank you. Mr. McCallum?
Thank you, sir. Unfortunately, the NNG have a bit of an issue in terms of availability of main witness, week commencing the 25th of March and week commencing the 1st of April, which it sounds like is perhaps the dates that others are suggesting. As I said earlier, I think we would only require a half-day hearing session, if indeed that's required at all, depending on how conversations go with the acquiring authority over the coming months. But if a half-day could be accommodated, sir, any other time in February or March, would be appreciated.
Okay, thank you. That's a witness availability, main witness availability, I think you said. Is that correct, sorry?
That's correct, sir, yes.
That's okay, thank you. Okay, right, thank you for that. I'll have account of that when we decide ways forward on next steps. My last substantive point is the question of a site visit. And my expectation would be, if we're going to look at alternative sites, then we'll have to arrange a site visit, but we'll do that around the time of whatever oral procedure is decided upon at the end of March next year or whenever. My question really is, aside from those who had the opportunity to attend on the 28th of August, and aside from the alternative site suggestions, is there anybody who would wish me to conduct a site visit for any other purpose? So I think it's right. I'll have to look at the alternative sites if I go down that track, but an opportunity has been given. I think certainly William Dunlop, that was inconvenient for 28th of August, and they reserved their position in that regard. And I think it was Mr. Taylor as well did the same. But it'd be useful if anybody thinks that there's any need for me to pay a further site visit other than for the purpose of looking at alternative sites. It'd be useful to know that. And if there is, then we can look in terms of scheduling something with that in mind. But if anybody has such an indication, if you can give it now, or even just in the follow-up to this meeting, if there is anybody who wishes me to look at anything other than what I've looked at already and other than in relation to alternative sites, it'd be useful just to be aware of that, because there's no reason why that can't be scheduled reasonably soon, I wouldn't have thought. But again, I open up if anybody has any thoughts on that. Mr. Carroll, possibly Mr. Jimison, or Mr. Carroll first of all.
Yes, sir. My understanding is that there hasn't, for reasons you stated, there has not even been a first site inspection for the Dunlop's farm. And I think it would be beneficial for you to have a site inspection of that. As indicated at the previous pre-inquiry meeting, that is something that might take the best part of a day for that to be done. And that is something, therefore, I request that you do on an accompanied basis.
Okay, thank you. And Mr. Jimison?
I was just going to build upon that. I think when we took our walk last time, we actually didn't explore all the plots of potential land. So I think just in terms of completeness, that should be concluded, which I think just echoes Mr. O'Carroll's point.
Yeah. Okay, well, I'll look at the date for that. As I say, this may all be dependent ultimately on the question of what's done about alternative sites, but I'll note the fact that there's still a desire, at least as far as William Dunlop is concerned, to have a further site visit organised, and we can maybe arrange that at an appropriate time into the new year. Okay, right, thank you for that. I had no other bits of business for just now. I will try to draw all of this together in a note that I'll circulate for comments as to accuracy as soon as I can. But were there any other matters, any other business that needs to be addressed today? And I'll start with Mr. Mackay.
Not for me, sir. I'm assuming Mr. Hamilton doesn't have any other issues he wants to raise procedurally.
Nothing from me, sir.
Okay, and any other party? Then just shout out if you do. Okay, doesn't sound like that. I'm not going to fix a date for the next pre-inquiry meeting at this stage, but I've noted the representations as to what the appropriate date that would be, and I'll check availability from the DPA perspective. So thank you all again this morning for your contributions to the meeting. Honestly, a note will follow, and if anything is inaccurate about that, and no doubt you will point it out to me, but I'll try and ensure that I reflect as accurately as I can the discussion for this morning. So thank you all once more.
Thanks, sir.
Thank you.
Goodbye.
Thanks, sir.
Thank you, sir.
Bye.